Next up, we have a commissioner training session presented tonight by City Attorney Megan Lamb. Please proceed.
All right. Hi, everybody. A lot of this is probably going to be a little boring for you, but it's really, really, really important. So we're going to go through it. Tonight, we're going to do a refresher on agendas, how we run through the agenda during the meeting, and how we conduct the meetings and what expectations are during the meeting of the commission and how the commission can best do their job during meetings. So first, all of you, before becoming public officials, or as soon as you became public officials, you needed to complete Open Meetings Act training. I am sure you remember most of that training, but just as a little refresher, anytime you have a majority of a quorum of you together discussing public business, you technically need to follow the Open Meetings Act. So there are 7 commissioners. That means anytime the 3 of you are in the same place and you are talking about commission business, you have to follow the Open Meetings Act. You have to have an agenda posted. You have to have easy access for members of the public. The Open Meetings Act states it is contemporaneous communication between a majority of a quorum. So if 3 of you are emailing back and forth about commission business, if you're emailing back and forth fast enough, technically that's a violation of the Open Meetings Act, which is why everyone is always counseled, like, don't email each other. If you have questions, don't ask your fellow commissioners, ask staff, right? The meeting must be open and accessible to the public. Agenda for any meeting must be posted at least 48 hours in advance of the meeting. Any meeting is required to have minutes taken and then approved. And you may only take action at a meeting on items that are on that meeting's agenda. One thing to note, you guys are probably never going to have a special meeting just with the way a planning and zoning commission works. But there are special meetings and then there are regular meetings. Your regular meetings are your scheduled meetings that you set forth every year. A special meeting may be a meeting that falls outside of the regular schedule. If you have a special meeting, you can only discuss items on the agenda. During your regular meetings, you can technically discuss anything you want. You can discuss what you guys approved last month. Who cares? But if it's a special meeting, you can only stick to agenda items. Another thing to note, because this came up with another public body I had earlier today, the quorum requirement requires, or in order to hold a meeting, it is required that you have a quorum in person. So if 3 of you are in person and 1 of you is on Zoom, you do not have a quorum and you cannot hold a meeting. You need to have at least 4 of you in person like you do today in order to hold a valid meeting. I had a unit of local government today, 5-member board. 2 of them are in the room, 1 logs in on Zoom, and I had to give them the bad news. Sorry, guys, you can't have your meeting today because you don't have 3 in the room. There was a special rule during COVID. Knock on wood, if another public health crisis happens, I imagine that rule will be revived. But until then, 4 of you need to be in the room. So, getting specifically to your PZC, now that we've had a little OMA refresher. Your PZC agenda follows a specific order. You have your call to order, your roll call, approval of the minutes, citizen comment, any public hearings or presentations that may come up that night, unfinished business, new business, and additional items. The top of the agenda is basically your preliminary matters. You're going to have the same thing every single meeting. You'll have a roll call. The roll call is important to establish a quorum and to record the names of all commissioners who are present at that meeting. Minutes must be taken of every meeting, and they must be approved the latter of 30 days after that meeting or the next time the commission meets. So if you guys, I have some units of local government that meet twice a month. They don't have to approve the minutes at the next meeting, although it's always a best practice to do so. Citizen comment, which is at the top of your agenda, is also required. A unit of local government can impose reasonable limits on citizen comment. They need to be established in written rules. Those reasonable limits might be time limits. That said, citizens, while they do have the right to comment on any city business at your meetings, they do not have the right to be crude or obscene. So anything like that, you don't need a written rule to shut someone down if they start swearing. And when I say crude, offensive, I don't mean like if somebody comes up here and talks about how they hate lawyers and that offends me as a lawyer, right? That's not the level of offensive that we're talking about. We're talking about something that would offend any member of the general public. All right. Hearings are your next item. And for you guys, hearings are the big ticket, right? They're probably the most important item on your agenda when you have them. Most of what you all are going to take action on is going to require a hearing. Rezoning, variances, special uses. They're not just required by city code, they're also required by the Illinois Municipal Code. They should be recorded, which is why you'll notice today we don't have a court reporter, but typically there's a court reporter. And one little aside, because there's a court reporter and she is taking detailed notations of everything that is said during this hearing, it's crucial, and you've, I'm sure, seen the chair and myself and Christy instruct the public about this, that no one talk over each other during a hearing, right? We go one at a time. This way she can more accurately take her notes and make a proper record of the hearing. Testimony should be given under oath, which is why at the beginning of the hearing, everyone gets to stand up and say their little oath. We try to catch people who maybe have changed their mind mid-hearing and decided, I didn't think I was going to speak, but now I think I want to. If you see someone who maybe didn't raise their hand and then they come up during the hearing to speak, it's okay to like flag Christy or the chair or someone and just be like, they didn't take the oath, because it's not a big deal. All we do is just make sure we administer it for that person. That's it. Let's see. The hearing is also crucial because it establishes a good portion of the record on which you should be basing your decisions. And because of that, you want to make sure any comments or questions that you may have about a specific land use decision that's coming for you as a commission, if you want those on the record, it is okay to speak during the hearing. The hearing does not just need to involve developer, property owner, who have you, and members of the public. The commissioners are also able to participate in the hearing and can benefit from asking questions during the hearing, making comments during the hearing, because your questions and comments are now part of the record, which is important. And because it's important, if you have concerns or if you're confused about something, that you ask those questions and you get those concerns out there. And I did not bring my water up here. Twice a year to fire district trustees. So I'm not seasoned with bringing my water. All right. So as I said, it is really important that if you have questions, you speak up during the public hearing, because we want those on the record. So you may be wondering, and I've alluded to this somewhat, how is a public hearing different from public comment, right? We have public comment on the agenda, and then we have a hearing. There are differences. During the public comment, as we saw earlier this evening, you are not required to exchange with the commenter. If there's a question that's asked of you, and it's a simple question, you think you can answer it, there's nothing legally prohibiting you from doing that. But sometimes then we can get into a hard spot where we've answered Mr. Jones' question, but now we're not going to answer Ms. Smith's question. And why does Mr. Jones get to have a conversation with you guys and Ms. Smith doesn't, right? So that's why it can be a good practice to just not answer questions during public comment. But It's important for the public to get up here and speak their mind and let you guys know how they feel about projects. Whereas with a public hearing, there's more back and forth. There's more give and take. It's a lot more involved. You'll have the developer will get up, they will say their piece, they'll explain their project. And at that point, members of the public for or against the project have the ability to get up, to make public comment during the hearing, as they would during the regular public comment portion of the meeting, and to ask questions. And at that point, a give and take is more expected than it is during public comment. So you will see members of the public get up and ask questions, and the developer then respond to those questions if they can. Try to clarify, try to explain things. There is an Illinois Supreme Court case, People ex rel Claren versus the Village of Lisle, that basically states a public hearing for land use does require due process rights for interested parties. And what that means when you have due process requirements is that they get to ask questions, they get to have a say, they get to cross-examine witnesses is the legal term for it. But basically, they get question and answer to some extent. They have to keep it limited to the topic of the hearing. If you guys are having a hearing on the Project Cardinal data center, somebody should not be coming up during that public hearing and asking about someone who's getting a fence variance. That is not relevant to that public hearing, and those comments should be restricted. It just confuses the record. Also, you can limit repetitive comments. If we see the same questions over and over and over and over again, especially if one person is repeatedly asking the same question that has already been answered, those comments can be limited. Once again, no obscene conduct, no offensive conduct. I typed offense, typo. No offensive or obscene conduct during the hearings. People should be acting with decorum. Once the hearing is done, you close it out, and then we move on to the business portion of the meeting. And this is really your show, right? First up is unfinished/old business. It's called unfinished business on your agenda. You'll see it as old business on others. It means the same thing. Anything that you had brought forth during a previous meeting but not come to a final determination on, you may have tabled. When you table it, it will show up as unfinished business on a subsequent meeting agenda. It doesn't change the agenda item at all. It still requires the same action it would have required when it was first introduced to you. So it's basically a way of just organizing the topics on the agenda. Next is new business. This is where new items are brought forth to be decided on by the commission. And finally, you have additional business on your agenda. These are informational items, updates on city council action, updates on PZC related items. I think sometimes you guys will get updates on like something the county is doing that you might find of interest. It's general updates. It's nothing that you all would need to take action on. Getting back to new business. So under new business, this is where your land use decisions are housed on the agenda, right? Most of the city's land use decisions must filter through the PZC, with the interesting exception of annexation agreements. So you guys will have variance, special use, rezoning, all of those public hearings take forth at the Planning and Zoning Commission, right? But an annexation agreement has a public hearing at City Council, as was briefly discussed earlier with public comment. So you don't see those. You don't see annexations themselves because they don't require a public hearing. But everything else that's a major decision filters through the PZC. There are criteria that need to be met regarding whether or not to grant that land use relief. Those are set forth somewhat in statute, but clearly in the city's UDO. And I just copied and pasted out of the UDO the different criteria that need to be met for a variance, a special use, also PUD. PUD is a special use, and for a rezoning. So when you look at that printout that you have in front of you, those questions are the ones that should look familiar because you're answering them for every single variance, rezoning, and special use application that you have before you. What we call that is the findings of fact. When you answer those questions, you are making findings of fact. You are saying, yes, X project meets Y criteria because of fact A. There are some easy ones like the relief will not obstruct the light and fresh air of surrounding parcels is generally going to be like yeah, duh, they're getting a fence variance. It's not going to change the air or the light of adjacent properties, right? And some are more nuanced and harder to answer. But it's important for you guys as the commission to make those findings of fact. You will see in a petitioner's land use application, there are responsive answers from the petitioner to these criteria. You may think like, well, those answers answer the questions. Not quite. The petitioner is not allowed to make the findings of fact. You make the findings of fact. You can look at the petitioner's responses and use those when you're making your decision, but those can't be the only basis of the decision. You can't just say like, oh, they said it, so it must be true. That's not good enough. It has to be, they said it, and I agree, I think the same thing. You have to use your own judgment as commissioners when you look at their responses. Briefly, you all know that you're an advisory body. So what does your decision mean for the city council? Most of the time, if you vote no on something, city council needs a supermajority to override you. I always forget it, so I have a little cheat sheet that I've shared with Christy before. So when we have a special use or a variation that you do not recommend to the city council, they need a 2/3 majority of alderpersons to approve and override you. With rezoning, they still need a simple majority for whatever reason. That's what the state has decided. That's how they do things. But yeah, so with some of your decisions, your no vote creates an extra hurdle for city council. Your yes vote doesn't. If you recommend a land use decision, simple majority of city council is all that's needed to approve that land use decision. We're going to get back to findings of fact because they're really important. And I should probably talk about them even more than I'm going to tonight. So, findings of fact. Once again, these are the criteria that you are going to base your yes or your no vote on. You have to look at the criteria in the city's UDO and say, here's a factual reason why the developer meets this criteria. You should be basing your decision off of what was stated during the hearing. That is why we have a hearing, or one of the big reasons, also because it's required by law. You should be engaging in a discussion with your fellow commissioners. If you have a land use decision and there is robust discussion between the commissioners when you're making that decision, then your findings are more likely to be looked upon favorably by a court, should it come to that. And you should rely on experts to guide your findings, which is why you get reports from your staff and explanations of exactly what the petitioner is asking for, whether or not staff support the petitioner, if staff have recommended conditions that they think would make the petitioner's variation or special use more palatable or reasonable for the city to grant. It is okay to rely on your staff there. And that's also why it's okay to give weight to the petitioner's responses to the criteria, because they also rely on experts. That said, though, do not blindly agree with their claims. Once again, I could go on about this. I could just repeat that over and over for an hour, but you guys would probably want to strangle me. Go ahead, Wally.
Can I ask 2 questions?
Is it about strangling me? I would be missed at home.
Oh, Wally, can you turn on your microphone?
Not about strangling.
Thank you.
All right. The first one is when the courts or a lawsuit against the city would cause a review of our decision. Is that right?
Yes.
Okay. When a court is reviewing our decision, generally, what is it that they're looking for or what they're looking at when they make that review?
That's an excellent question. So what they're looking at is whether you actually made your own findings of fact. There are court cases where the findings of fact are just the Planning and Zoning Commission repeating the criteria, instead of saying they don't obstruct neighbors' light and air because of this reason, they just said they don't obstruct neighbors' light and air. Stop there. That is an issue. So they want independent findings of fact. They also look to see whether or not your findings of fact, best way I can put it is are like reasonable and sensible. You can't say like, well, I know Joe Smith and he wants this variation because he wants to put a fence in, but he's a sloppy guy. He's never going to complete that fence and it's going to look terrible. That's your own personal opinion of Joe Smith. You can't use that as a criteria. That's another thing that they're looking at. So what a court is going to look at is, did you actually make your own findings of fact as a Planning and Zoning Commission? And did you use reasonable facts that are known to the public as a whole and known to the commission as a whole when making those findings of fact?
Okay. Great. Then that dovetails into my next question. In terms of information that's being presented at hearings, is that the only thing that you can base your opinion on? And let me just kind of wrap that question back around.
Yep.
Like, can you do your own research?
You shouldn't.
Okay.
No, you shouldn't, because your research is not Commissioner Green's research. And it's not Commissioner Linnane's research, and it's not Commissioner Forrestal's research, right? Everyone has different sources. Goodness knows when you Google, you get an AI answer right at the top of your Google searches these days. And I'm going to tell you all right now, a lot of times that's not correct, right? And I can't think of a specific case, but I know I have read of instances where independent research was frowned upon.
Okay.
Yeah.
That's it. No, those are the questions I wanted.
Excellent. Yeah, absolutely. And I think that gets back to the one don't that I did not mention is don't base your decision on informal information. You have to stick to what is given to you by staff. And look, if you're getting back to like doing your own research, if you have a question, if you're wondering like, well, how is this project going to affect stormwater drainage in the area? You could go on Google and look that up and try to figure it out, or you can call Christy and ask, and she has a better handle on who to ask And
Sure.
then she can disseminate that information to not just you, but
Right.
to your fellow commissioners. Also, because if you disseminate it to your fellow commissioners, you've now violated the
Right.
Open Meetings Act. But so that's why it's important, if you have a question, it's good to have questions. But ask your staff, rely on them to get you those answers.
Sure. Right. That makes sense.
Yeah.
And then the other piece
Yeah.
would be, all right, so let's just say, I mean, I did do research or I've got set framework. Like
Yeah.
it would be okay to repackage that and ask the staff, like, okay, I did research on this and found XYZ. Can you speak to that?
Yes, it's okay to ask them that, but I would just rather that you didn't do the research in the first place.
Or if
Go ahead,
I may, or if you come from an industry with knowledge of, certain aspects, it would be better to present that question to the petitioner
Right. Right. Yes.
at the meeting.
Right.
That's an excellent.
And I think procedurally too, if possible, you'd want to know of it
Exactly.
ahead of time.
It would be helpful.
Right.
It would be helpful so I can have the presenter or the petitioner be able to
Right.
respond to that question. But if you do have something that comes up in the middle of the meeting, it's best to bring it out, have the petitioner give their response, and then treat this as like quasi judicial, whereas almost you're a jury. So you
Yes.
can only rely on the testimony and the information provided during the meeting to come to your decision.
Christy is exactly correct.
Sorry, I didn't mean to derail you.
No, those were good questions. I like questions.
I actually got one.
Yeah.
So then if this comes to, this is going to piggyback off what Wally was saying. If this comes to a point where we're not getting enough, we don't feel we have enough information, is that at the point where you'd almost table it to get more information from the city and then deal with it the following meeting?
Absolutely. If you don't feel like you have enough information, do not feel pressured to make a decision. No one should be pressuring you to make a decision. If there's not enough information, and I feel like I've seen this
Mhm.
with projects before this Planning and Zoning Commission within the last year or so. If there's not enough information, it is okay to say, I'm not comfortable. I have questions. Can we table this? What does everybody think of that? There's nothing wrong with that. I would rather you guys do that than make a rush decision and sit around regretting it for, months to years.
Thank you.
Yeah. All right.
Can I just ask one question to
Yeah.
Megan? As far as the standards, can you explain like the weight that you put? So if some are a yes and some are a no, or some don't apply.
Yes. So all of the standards matter and they all have weight. As far as I understand, not one standard is more important than another.
Hmm.
So when you have, I'm trying to find my little, I printed myself off the list, but I lost it in my pile of paperwork. All right. So for instance, if we look at the standards for variations, we have a hardship to the owner would result, or the conditions upon which the petition for variation is based are unique to the subject property and are not applicable to the other properties. The difficulty or hardship is not created by any person presently having an interest in the property. For instance, you didn't get a permit and you built an addition on your garage that goes within the setback. And so now you need to ask for a setback variation because you did illegal, unpermitted work. Yeah, you created that problem. So that would weigh against the petitioner. But there are 1, 2, 3, 4, 5, there are 6 criteria, right? So if your petitioner created their own hardship, but you find like 4 of the other criteria fall in favor of your petitioner, then it's fine that they created their own hardship because it's about a balancing of the interests. And at the end of the day, after you look at the criteria and you make the findings of fact, you look at your yes, I think this meets bucket, and you look at your no, I don't think this meets bucket, and which one weighs more? Which one has more findings of fact in it? And which one feels like it has heavier more concrete findings of fact in it. So yeah, there is no specific one criteria that matters more than another. I'm going to talk about light and air again, because that one always makes me laugh because there are so few. So, well, with the last year maybe
Mhm.
excluded,
Mhm.
there are so few like variances, for instance, that would actually inhibit the neighbor's light and air. But still a criteria. It's important to ask that question and to answer it. So yeah, that was a good question, Christy. Anything else? Otherwise, I have a few things about FOIA to yell at you guys about, because I like yelling at people about FOIA. And then I'm
Just
done.
because I'm trying to delay getting yelled at about FOIA, I have one other question,
What's up?
right? When you are doing the public hearing, what's the agenda? Not that's the bad word. What is the order in the public?
Process?
Yeah, well, yeah. How does that? I mean, because there's an order. Like the petitioner speaks, the audience gets to ask questions,
Yeah.
then the board gets to ask a question. What is that? Or is that even something that's set?
By statute.
Right.
It's not, I don't think it's in the city's rule.
No, it's not in the city rules, but we usually do have a step. So what it'll be is the petitioner do their presentation, then the chairman will say those in favor of the petition, come up and speak, and then those against. Sometimes we mix them and just say if the public wants to come up and speak. And then the reason why we did the favor or against is to give you guys an opportunity to kind of see the weight of, the responses. And then after that, then it's your opportunity to engage. But you can engage at any time, even when people are asking questions. But then it's set for you guys to ask questions. And then the hearing is closed. Then it comes to staff during our presentation. And then after our presentation, your deliberation.
Yeah. So it's really just about keeping things organized. If you guys wanted to mix it up, I'm sure you
Right.
could. Although you really sensibly always have to have the petitioner's presentation first.
Yeah.
But regarding like public comment versus your questions, I've been at PZCs where the commission asks questions before the public does.
Mhm.
It's a preference thing of the public body. Whatever you guys want. Although I like the way you do it here. All right. Anything else?
Is there any particular standard you guys are confused on that you need a little bit more explanation on?
Guys, I know it's only 7:45, but I am not rushing. I've got all night.
Yeah.
Really. Go ahead.
I guess my only question would be,
Oh, you got to turn your mic on, Margie. There you go.
hello, can you hear me?
Lean into it.
Okay, now?
Yeah.
Okay, my only question would be is, we have to base the way we vote on what's presented and what we've determined here, not, let's say, a gut feeling,
Yes.
something that maybe you're just against.
Yeah.
Okay, that's,
I
which is how I try to vote.
think a good example of this would probably be cannabis.
That's
Because
what I'm thinking of.
cannabis, like you can be personally opposed to cannabis use. You could be like, I don't like it. I don't do it. I don't think anyone should do it. I think it is bad for people. Or I think it's illegal federally and therefore it's legal everywhere. Whatever your reasons, you can not approve of cannabis use. Your personal feelings about cannabis should not enter into your decision on whether or not you're going to approve a dispensary in the city. Because remember, you don't have to go to the dispensary. You don't even look at it when you drive by it, whatever, right? That it would be inappropriate to allow your personal feelings on something in that way to influence your decision as a commissioner. That said, if you guys had like 5 dispensaries and you're like, okay, it's too much, it would be okay to say like, no, I think we have too many dispensaries.
Okay.
Although to clarify, you can't have 5 dispensaries. It was a bad
That's where you-
example.
Yeah, thank you.
No problem. All right, let's talk about FOIA. And I'm not going to yell. It takes a lot to get me to yell. So FOIA.
Takes a lot.
FOIA is serious. I, the other day, had a member of a public body tell me with pride that they did something on their personal computer because they did not want it to be subject to FOIA. I'm sure you all realize it does not work that way. If it is city business, it doesn't matter if it is your city issued iPad or your own cell phone or your work computer. City business is city business no matter where it happens. So you cannot create a document on your personal computer to get away from having it subject to FOIA. And that is a real world example. I did not make that up. Freedom of Information Act facilitates public access to public documents. This is a public board. The city is a public body. You serve the public for better or worse, and therefore, barring some exceptions, every document you have is subject to public access, right? Your emails, your text messages, any other records that you have, those are subject to FOIA. That said, if you're texting with each other about a good cake recipe or going to Wally's birthday party or something that is not city business, that's not subject to FOIA. And the same rule applies, getting back briefly to the Open Meetings Act with the Open Meetings Act. All right. If 4 of you are at Wally's birthday party, because Wally's a popular guy.
It's a good birthday party.
And you are just talking about how great the cake is, how much you like the gin and tonic or beer that you're drinking, what have you, that's fine. You're not violating the Open Meetings Act. If you start talking about a decision you're going to make next week at your PZC meeting, now you're violating the Open Meetings Act. And the same rule applies with FOIA. If you have personal private communications with each other about personal private things, those are fine. Those do not apply. Those are not protected, or those are protected. So don't be afraid to go to Wally's birthday party, which I expect we'll all receive an invitation to now. And what else? Oh, exemptions exist, but FOIA is always interpreted, another typo, in favor of transparency. So do not rely on exemptions. If you know of an exemption under FOIA, like, what's an easy one? Personal and private is kind of duh. Like, obviously personal information is exempt. But even then, don't type out your personal stuff in an email that's also commingled with city business. Because now you have city business and personal business in that email to another commissioner, and someone FOIAs, and the city business in that email is subject to that FOIA request. You are now relying on staff to redact that information. And staff at Yorkville is excellent, and they do redact the information, and they do a great job at following FOIA. But why leave it up to chance? Why even take that risk? So keep the personal and the business separate. Do not talk about business that you don't want the public to know about. If you have something nice to say, or something mean to say, something not nice to say, go home and write it down and tear it up and throw it away. Because that stuff comes out in FOIA and it's embarrassing and it's ugly. And there is my FOIA speech. Does anybody have FOIA questions? Oh, also check your spam filters and check your junk, because if you have a FOIA request that is inadvertently sent to one of you instead of the city's FOIA officer, and it ends up in your spam, there is some contradictory case law that says that the day it enters your spam filter is technically the day the city receives it. So you could get in trouble. So just periodically, if you have a city email address, every couple days, just click on your spam and see what's in there. make sure there's nothing hiding. That's it. Anything else? Any other questions?
And I've got a question for you just to make sure, just so you know we're listening. What does it look like for us when somebody FOIAs the city? And what I'm saying for us as plan commissioners, somebody FOIAs the city, that they wouldn't FOIA us directly.
No.
So how does that look for us?
Generally not. No, generally they will FOIA the city's FOIA officer
Right.
directly. And if they are plan commission documents, if somebody requests all commissioners Worderix, did I say, is it?
Yeah,
Worderix?
you got it.
This is why I use first names. If they FOIA all of Commissioner Worderic's emails with Miss Barksdale Noble, then Jory or Monica or someone else at the administrative level of city staff will probably reach out to you and say, we received a FOIA request for all of your emails with Christy. Can you confirm if you have any emails with Christy from this time period? And if you do, can you send them over to us?
Okay.
That's how it would look.
And then to take that one step further, say that I communicated with Christy, I deleted the email the next day. What is my responsibility to keep that communication?
It depends on what the communication is.
Okay.
If it was like, hey, Christy, are we still having a meeting tomorrow night? You probably shouldn't delete it. Just, you know what? Don't delete them. Don't delete them, because the problem is, if you have, like, I'm trying to think of how this would work and how the public access counselor would view this, or God forbid, a court. If you have a practice of, I delete every single email after 7 days,
Mhm.
that is what I do, then you're probably fine. If you pick and choose emails here and there on like what to delete and what not to delete, there's where you can get in trouble. If you inadvertently delete something, the best thing to do is to notify city staff that it happened. Oops, I did this, my bad. And that way there's a record that you had an oopsie and you deleted something you weren't supposed to. And it happens before a FOIA request comes in for that document. So it's obvious that you weren't trying to avoid responding to FOIA, because that's our concern. We don't want it to look like you're hiding anything. And I've had people delete things on accident. I had a unit of local government that thought they archived a Facebook post, but they accidentally deleted it. So what they did was they notified staff, we had this post, I thought I archived it, I accidentally deleted it. I'm trying to work with Facebook to see if I can get it back. You know, and that way there's a record that something happened on accident. So, you know, going more toward transparency, if you delete something that maybe you shouldn't have, let staff know.
I don't delete my emails.
There you
Okay.
go.
Well, I guess that looks a lot different for us, that, you know, we're board members volunteering. And
Yeah.
I don't mean that in a diminutive way. It's just that we are probably going to record keep a lot differently than staff or somebody who's on the city. I get what you're saying. I don't disagree with it. Just I think that it can be looked at from our perspective in a different manner.
It's a good question. And that's why, like, I think if you really are insistent that you need to delete emails, I would make it a practice of, I delete every single email after 1 month. That is what I do with all my emails. But technically, keep in mind, your emails about city business could be viewed as a public record, and public records should not be deleted.
Okay.
You know, and I mean, we could get into the nuances of like, is scheduling a meeting the city business that we shouldn't delete? Some people would say yes, and some people would say no. So I'd always err on the side of don't delete.
Okay.
Anything else? No?
Thank you.
You good? All right, guys, if you have any other questions, Christy has my email.
Yeah.
Feel free to let her know.
Yeah.